Cool, thanks, Kelly. So like Kelly said, my name is Richard Prebil. I'm a staff attorney in the Veterans Advocacy Project at Legal Aid of Southeastern Pennsylvania. And I'm really excited today to get to talk about veterans benefits. So let's go ahead and get started. All right, so generally when we're talking about veterans benefits, we're talking about a whole host of different things available for individuals who've served, who have served in the military, and there's different benefits available from education benefits, insurance benefits through the health administration, pension benefits, different things to allow individuals to get training for jobs, home loan guarantees. But what we're going to focus on today primarily is what's called disability compensation or service-connected disability compensation benefits. We're going to talk about the initial application, what that looks like, and then go all the way through the different stages of appeal that are available for veterans. So first, what I always want to start with is just that there are a lot of acronyms when we're talking about the VA, when we're talking about the Department of Defense, and it's really important just to recognize that there's a lot of different acronyms. So I've tried to put the main ones on this slide that we talk about as when we're talking about applications and appeals. If I say an acronym and it's not on this slide, or you just want me to say what it is, please put it in the chat box and I'm more than happy to explain what that is. I'm so used to saying them a lot that I don't realize that I'm just just an entire sentence is an acronym, and that's what it is. So please feel free to stop me and we can definitely go over that. That's no problem. So besides for that, the first thing we want to talk about when we're talking about service-connected benefits or any kind of benefit with the VA is that an individual upon their discharge from service receives one of 5 different kinds of what's called a discharge status or characterization of discharge. There are a few others, but for this purpose, we're not really going to focus on them. So they range everywhere from a dishonorable discharge to an honorable discharge. If you receive an honorable discharge from the service, if you prove service connection, you're going to be eligible for benefits. You're going to be eligible for a whole host of benefits available to the veteran through the VA. If you receive a dishonorable discharge, you're never going to be entitled to benefits unless you go through a discharge upgrade process, which we're not going to really talk about today. I'll mention a little bit in a little bit. The focus of what we're going to talk about today when we get to characterizations is going to be the bad conduct, the other than honorable discharges, which is an administrative, the other than honorable is an administrative separation. Bad conduct results after a court martial. And basically what you're going to be doing when those happen is you're going to try to prove to the VA that the individual should be considered honorable, and we'll talk about why that's important in a little bit. But I just want to set the stage here to say that there are different kinds of discharges when an individual leaves the service, and this is what they are. So when an individual leaves the service, they will receive what's called a DD-214. And the DD-214 is one sheet of paper that basically explains every bit about a person's time in the service. It says their name, social security number, the rank at the time of their discharge. But what it also tells us is the date they entered service, when they left the service, if they had any foreign service, so if they were on ground in another country, if they had any sea service, what their job was, if they received any medals, campaign ribbons, decorations. But there's also some really important information in here that tells us, for example, for this veteran, This tells us that they served in a designated imminent danger pay area. And then it says that they served in Iraq for two tours. And that's helpful as an advocate, and I'll explain why in a little bit. But that two lines on their DD-214 really helps us as advocates to be able to help the veteran in their application. Now, that all is extremely important, but what is really important when you're looking at a DD-214 is this little bottom section, boxes 23, 24, 25, and below. And the reason for that is these boxes specifically say what the veteran's characterization of service was, what their narrative reason for separation is. And so as you can see in this example that I've provided, the characterization of service is under other than honorable conditions, what we call an OTH. And generally that means that this veteran is not going to be entitled to benefits from VA. And then we go a little further down and we see the narrative reason for separation. This could be anything from marijuana usage, alcohol usage. It really is just a really short explanation of why this service member was discharged the way that they were. And in this example, it says in lieu of trial by court-martial. So that gives us a little something to make sure that we're paying particular attention to when we look through this veteran's documents, because we want to understand that a little more and unpack that so that we can advocate for them before VA. Let's see if now my slides aren't moving. Okay, so why is all this important? Because under Title 38 of the United States Code, there is a specific definition of what a veteran is. And if an individual who is discharged from the service does not meet this statutory definition of veteran, they're not going to be able to get benefits from VA. So to be considered a veteran, you have to have served in the active military, naval, or air service and was discharged or released under conditions other than dishonorable. Active duty is pretty straightforward. An individual who was on active duty, they received a DD-214 following their active duty. Like it says here, there are little exceptions when an injury occurs while an individual was on inactive duty training or in the reserve component, but injured. But we're not going to really focus on that. Military, naval, or air service, that's pretty straightforward. They were in one of the branches of the military, and they were discharged or released under conditions other than dishonorable. Now, remember what we talked about at the beginning. There are 5 different kinds of discharge statuses available to service members upon their separation from the military. VA takes Title 38, Section 101(2) to mean that they don't look at all 5 discharges. For the VA, you're either honorable or dishonorable, and there's really nothing in between for them. And so when we have a veteran, like the veteran I was talking about and showed the DD-214, there are those who receive other than honorable discharges. So what do we do for those? And we'll talk about that in a second. There are statutory bars to be considered a veteran. If you were discharged as a conscientious objector, discharged as a result of a general court-martial because of desertion, if you were received an other than honorable as a result of being absent without leave for at least 180 continuous days, there is an exception for compelling circumstances, which we actually will talk about in a second. There are also regulatory bars for service, for services from VA to be considered a veteran, that the VA themselves has laid out in addition to these statutory bars. One of them is receiving an other than honorable to escape trial by the general court-martial, being discharged for mutiny or spying, an offense, an offense involving moral turpitude, or willful and persistent misconduct. We'll talk about those specific definitions in the next slide. And also for what's still in the regulation, homosexual acts involving aggravating circumstances or affecting performance of duty. There is currently in the Federal Register, actually the comment period I think just closed, a proposed rule change to include any sexual acts for this, to specifically take out homosexual acts. But now we're talking about a characterization of discharge. So for individuals who've received that other than honorable or bad conduct discharge, how can we make the VA accept them as a veteran so that they can get benefits? We go through this thing called a characterization of discharge determination. And it doesn't change your discharge. It doesn't change that DD-214 document. It doesn't give the veteran a new DD-214. What it does is it tells the VA that you should recognize this veteran as honorable and therefore give him or her benefits that they are entitled to as a result of their service. Generally, the argument that we're making in this situation is that their discipline problems, if there were any, were minor and their service was otherwise honest, faithful, and meritorious. And now we have the definitions that I said we were going to get to. So moral turpitude is a willful act committed without justification or legal excuse, which gravely violates accepted moral standards and would be expected to cause harm or loss to person or property. Then we also have willful misconduct. So willful misconduct is willful and persistent misconduct. So willful misconduct is an act involving a conscious wrongdoing or known prohibited action involving deliberate or intentional wrongdoing with knowledge of or wanton and reckless disregard for its probable consequence. Persistent means just what we expect persistent to mean, ongoing over a period of time or conduct that recurs on more than one occasion, but multiple offenses don't automatically mean persistent. So if a veteran, let's say they're discharged as a result of marijuana usage. Marijuana is illegal at the federal level, so it is illegal for soldiers, sailors, airmen, Marines to use. And let's say that that's the reason for their discharge. The VA could, in theory, deny someone benefits for willful and persistent misconduct if they have used it multiple times, and that is totally possible. There are definitely arguments that you can make around it, but that could happen. One of the things that you really want to focus on when you're advocating for this characterization of discharge determination is that the misconduct or the alleged misconduct wasn't willful. Let's go back to the marijuana example. If an individual has been in combat or has experienced some other traumatic event, self-medication can happen through the use of marijuana. And if you make the argument that the individual was self-medicating, or can make the argument that the individual was self-medicating, you can probably make the argument that it wasn't willful. It wasn't deliberate or intentional wrongdoing. They were doing it to help make themselves cope with the trauma that they had experienced. There are a lot of ways when you work with individuals who have experienced trauma to be able to help them access these services by arguing that anything that occurred could have been self-medication, or something could have been the result of undiagnosed post-traumatic stress or undiagnosed depression, or any other mental health disability. So when you're looking at this characterization of discharge, you're looking at the reasons surrounding the veteran's discharge, what occurred, the events leading up that occurred to their discharge. And is there anything that you can do to argue around that it wasn't willful and persistent misconduct? It wasn't what they call moral turpitude. Now, There is also, like I mentioned before, for an individual who goes absent without leave, there are compelling circumstances and mitigating factors. And now that's right now under the law that is only for going absent without leave. And then these are what the compelling circumstances are under that. However, there is a proposed rule that was published in the Federal Register at the beginning of July to extend this not only to being absent without leave, but for individuals who, for the moral turpitude, for willful and persistent misconduct. So we look at these, so it's kind of like what I was talking about earlier. We look at these potential mitigating factors, a clinical diagnosis or evidence that could later be medically determined to demonstrate the existence of some kind of mental health condition, combat-related or overseas-related hardship, sexual abuse or assault, duress, coercion, or desperation, family obligations, age, education. So there's a lot of things that as advocates we can do to try to argue around the individual's discharge with VA to ensure that they have the access to services that they need. So what path are we taking here when we're talking about going through the characterization process? So like I said, there's this thing called a discharge upgrade. I'm not going to talk about that today, but just briefly, a discharge upgrade is an administrative process through the military branch that the individual was discharged from. And what that does is allows them to talk to or apply for an upgrade of their discharge for various reasons. That process takes a long time. The shortest time you're looking at is probably 12 to 18 months. And so if the end goal is for a veteran to receive some kind of benefit that they couldn't get just through the VA, discharge upgrade may be helpful. But if the veteran is just looking for a benefit from VA, like monthly compensation, healthcare, something like that, just going through the characterization process could be extremely helpful for them because it is a relatively much quicker process. When I say that, VA process is extremely slow. We're going to talk about those numbers in a little bit, but it can potentially be a lot quicker than the 12 to 18 months you're looking at for an initial decision on a discharge upgrade. So that's the characterization of discharge determination. It's a part of your application when you send in an initial application with the veteran, knowing that they have a less than honorable discharge, and you just argue to VA as to why they should be considered honorable. So before I move on to the actual service-connected claim, does anyone have any questions about characterizations of discharge? Okay. So there are three factors, three elements to a service-connected disability claim. You have to have a current disabling condition, you have to have an in-service injury, and you have to have a nexus between those two. So to prove a current disabling condition, you have to have competent evidence that the veteran currently has a particular disability. Competent evidence is evidence by anyone, provided by anyone who is qualified through education, training, or experience to offer a medical diagnosis. So an MD saying that an individual has a back problem, a PhD saying that an individual has post-traumatic stress disorder. You could potentially work with, I've worked with nurses, social workers, anyone who is competent to offer a statement or opinion about a medical diagnosis is able to offer this kind of evidence. Also, it has to be current. So the veteran has to have a presently existing disability. It can't be something that they had and then went away. it has to be something that they currently have on the date that they file the claim. So that's really important. If it does get better later on after they've been approved, that's okay. They'll fix that. The VA will fix that later on. But what we're looking at is just on the date of the application and during the pendency of the claim. But also what you want to be aware of is disabilities that are non-service connectable, such as congenital defects, personality disorders, and disorders as a result of alcohol, drug, or tobacco use. I say that cautiously because there are ways around that, and I'm going to talk about that in a little bit. But generally, if an individual has a disability as a result of alcohol, drug, or tobacco use, it's not going to be service connected because that's considered by VA to be as a result of the veteran's own doing. So an in-service injury or event, you have to have medical or in certain circumstances lay evidence of an in-service occurrence or aggravation of a disease, but you have to have corroboration. So basically what you have to show here is that the veteran had an injury or some event that caused an injury in their service, and you have to prove that this occurred. As long as misconduct on the part of the veteran is not involved, the kind of circumstance that can be used to establish service connection is nearly unlimited and does not necessarily have to be related to military duties, as long as it happened between the day the veteran entered service and the day that they were discharged, so long as the veteran was not, say, on like reserve duty or something like that. And the evidentiary requirement for an in-service injury and the evidentiary requirement for anything related to VA is it has to be demonstrated at a minimum that it is as least as likely as not, or 50%, that there was an in-service occurrence or an event or in-service aggravation. So everything at VA is supposed to be veteran-friendly. Everything is supposed to be, when you weigh everything and it's equal, you're looking at it in favor of the veteran. So that's the evidentiary standard for everything that we do with VA.
I could just interrupt quickly. This is Kelly, and I'm launching the first of the CLE poll boxes right now. It will be up for 1.5 minutes. Please respond if you're looking for CLE credit for your participation. And Richard, please feel free to continue. Thank you.
Cool. Okay. So now we're going to talk about, there are special rules for 3 different kinds of veterans that I want to talk about in particular when we're looking at in-service injury or events. So the first one I want to talk about is combat veterans. Now the reason that there are special rules involved is because there are different levels of, like I said, there's evidentiary standards when we're talking about general in-service injuries, but what you really have to prove is that the veteran themselves were injured. And there are special rules for combat veterans for what's called fear of hostile military or terrorist activity, and veterans who are survivors of what the VA calls personal assault. And the reason for the different evidentiary standards is, we'll talk about in a little bit, of what's actually required to corroborate what the veteran experienced. So for combat veterans, in the case of any veteran who engaged in combat with the enemy during a period of war, satisfactory lay or other evidence of a service incurrence or aggravation, if it's consistent with circumstances or conditions of hardships, and everything's supposed to be resolved with, of course, reasonable doubt in favor of the veteran. What this is doing is it's lessening a little bit the evidentiary standard, the corroboration required in order to prove that the veteran was actually specifically injured. So we'll talk about each of these sections in a little bit. Okay, so engaged in combat. So the VA is not required to accept statement that the veteran was in combat, but you can prove that the veteran was in combat if they have service records indicating that they were in combat, which is absolutely conclusive. So if their military personnel file shows that is written in there that they were in combat, if their military occupational specialty or their job says that they were someone who would be in combat, for example, in the Army, if you're an infantryman or any of the other branches where your job is infantryman, grenadierman, something like that, that it would be assumed that you would be in combat. That could be proof of engagement in combat. Military decorations as well. One of the military crosses, Air Force Cross, Navy Cross, the Combat Action Badge, the Combat Infantryman Badge, a Purple Heart, or a Silver Star could all prove that you were engaged in combat, because all of those require combat. VA General Counsel precedent says that the ordinary meaning of engaged in combat requires that the veteran have participated in events constituting an actual fight or encounter with a military foe. So that's kind of why we use those different corroborations is because they fit into that council precedent. During a period of war, in order to fall into this special rule category, you have to have been in combat during a period of recognized war. There are specific dates for everything. We are currently in a period of war, which actually has not ended since 1990. The Gulf War started August 2nd, 1990, and has actually not been ended. So any individual who's engaged in combat since August 2nd, 1990 in a recognized location does potentially have the ability to use one of these special rules. And it is important to note that for individuals who served during Vietnam, there are different rules for those who were in the Republic of Vietnam and those who are outside of the Republic of Vietnam. So anyone who served in, for example, Laos, Cambodia, there are different days for those veterans as well. The combat veterans evidence must be satisfactory to determine that it has to be credible, plausible, and capable of being believed. And it has to be consistent with the circumstances of their service. So that's why it's important when an individual has an infantryman job, a military occupational specialty. It would be consistent with the circumstances of their service if they were in a combat zone that they would go into combat. If their job wasn't one that you would normally expect them to go into combat, then it's going to be a little harder to make that argument that they would fit into the combat veteran special rules. Now, there are other special rules that they may fall into, but maybe not the combat veteran one. There also cannot be clear, convincing evidence in the record against incurrence or aggravation during combat. So all of this is to say that when a veteran comes to you and says, I want to file for service-connected disability benefits for post-traumatic stress disorder, which I have been diagnosed for, and the reason that I have it is because I was in combat in Kandahar, Afghanistan during this period of time, then what you can do is say, you go through these 5 steps and you see that the veteran meets these requirements, and then the veteran's statement themselves could potentially be full corroboration of their in-service injury. Their statement about what occurred, their statement about what they experienced could be enough to allow for their application to be granted. Now, the next special rule that we're going to talk about, this is the fear of hostile military or terrorist activity. To qualify under FHMTA, it has to be related to a fear of hostile military or terrorist activity, which we'll talk about that specific bit in a bit. A VA, now this is a very different part of this regulation. A VA psychologist or psychiatrist has to confirm that the claimed stressor is adequate to support a diagnosis of post-traumatic stress or some other psychiatric diagnosis, and that the veteran's symptoms are related to the claimed stressor. So the different part of this regulation is that a VA psychologist or psychiatrist is the one who has to provide a diagnosis. Now that's hard when a veteran doesn't have access to VA care. There are, and we'll talk about this in a little bit, things that we can do to get the VA to make this diagnosis through what's called a compensation and pension examination, which occurs after the veteran's application goes through. But we'll talk about that in a little bit. You also have to show that the claim stressor is consistent, again, consistent with the places, types, and circumstances of service. Now, what is fear of hostile military or terrorist activity? The veteran experienced, witnessed, or was confronted with an event or circumstance that involved actual or threatened death or serious injury from a threat to the physical integrity or a threat to the physical integrity of the veteran or others, such as from an improvised explosive device, a vehicle-embedded IED, artillery, rocket, mortar, grenade, small arms fire, attack on friendly military aircraft, and the veteran's response to the event or circumstance involved a psychological or psychophysiological state of fear, helplessness, or horror. Now, I am not a medical professional. That's a lot of things that are going to need to be worked out with a medical professional, an MD, a PhD, psychologist, psychiatrist. And what we're doing when what we really want to focus on when we're arguing fear of hostile military or terrorist activity is that the veteran was in a place that they either experienced, that they had a actual or threatened death or serious injury or threat to the physical integrity of themselves or to someone else that was close by them from one of these things. And as a result of that, they were in a state of fear, helplessness, or horror. And so what we want to do is we look through their military records, we look through medical records to see what any psychologist or psychiatrist has put in there to see if they fit within these requirements. Okay, just as a warning, the next section that I'm talking about is going to be on sexual assault. So if you feel uncomfortable talking about that, it'll be about less than 5 minutes, so please feel free to come right back. So the next section is the special rules on personal assault. This is what the VA calls when an individual survives, generally we're talking about survives what's called military sexual trauma. Now, the reason that there is different rules for this is the VA has realized that a lot of people who survive sexual assault do not report their assault, do not report it to their commanders, maybe don't talk about it to anyone else for years. I worked with a client who served during Vietnam and told nobody, not even his wife, who was his girlfriend at the time, until we started working together almost 40 years after he was discharged from the service. 40 years after he was discharged from the service. It's really hard to talk about, it's really hard to prove a sexual assault or any kind of personal assault when there's no proof of it at the time. So what the VA has done in order to help individuals receive compensation is they've lessened the corroboration standard, like we've been talking about, and they can receive evidence from sources other than their service records and other than the general record that we would expect to see proof of an injury in. And this can be records from a law enforcement authority, a rape crisis center, mental health counseling, hospitals or physicians, pregnancy tests, tests for sexually transmitted disease, statements from family members, roommates, fellow service members, or clergy. Now that's just talking about, they told me that this happened. But what about for individuals who never talk about it at all? Evidence from behavior changes can also show, can also prove the claimed assault. A request for a transfer, for example, deterioration in work performance, substance use, episodes of depression, panic attacks, unexplained economic, social behavior changes. This is really, and when we're talking about this, it's really important to have the veteran maybe talk to family members around that time. The veteran that I talked about just a little bit ago who didn't tell his wife about the assault, when he applied for benefits, she wrote this really wonderful 3 to 4 page letter just explaining about how he was before the service, during the service, and after the service, and all of the changes that took place with him. And she remembered almost the day when he came back and he was different, which lined up exactly with what he had explained was the date of his assault. And that was, like I said, he'd never told her about that, but she saw his change in character. And that was extremely important in proving this to VA because, like I said, he never reported it to anybody, never talked about it with anybody. So showing all of these things can really help someone get maybe not necessarily the closure of this assault, but have someone recognize that, yes, this occurred. Because in the VA, in the Department of Defense, this is a really bad problem. And just having someone recognize that, yes, this occurred can be extremely empowering for people. Okay, so those are the first 2 parts of a VA claim. The next thing you have to do is you have to show a nexus between the current disability and the in-service injury. And again, our evidentiary standard is 50%, as least as likely as not, that the current disability is related to service. If the determinative issue involves medical etiology or medical diagnosis, you want medical evidence. You want a doctor, a PhD, an MD, a social worker. Like I said, I've had nurses working with me in the past who've been able to do this, who've been able to connect the in-service injury and the current disability. If the determinative issue is not medical expertise, lay evidence can sometimes be competent to sufficiently establish it. For example, if a layperson is competent to identify a medical condition, I saw that his leg was broken. His bone was protruding through his shin or through his skin or something like that. That's a layperson can talk about that. A layperson reporting a contemporaneous medical diagnosis. I was sitting in the room when the doctor told him this. Lay testimony describing symptoms at the time, which supports a later diagnosis by a medical professional. That also works with what we were talking about before with a change in a person's character. So this is what it was like for them at that time. And then later on, they have a diagnosis of post-traumatic stress or whatever it is. Having those 2 things can be extremely helpful. And lay testimony, especially by a spouse, by individuals who the person served with, family members, whoever it can be extremely helpful in these situations. Now, there are 5 specific Nexus things that I want to talk about. First is direct service connection. It's what I've been talking about. It's clear evidence of a disability, an incident, and something linking the two. That's direct service connection. It's very cut and dry. We also have something that's called secondary service connection. It's when one disability is the result of another, and you can get service connected for the other. So say a veteran has a diagnosed back issue. They have service-connected back issue. Because of their service-connected back issue, now they have a problem walking. Because of their problem walking, now they have a hip issue. That hip issue is not service-connected in and of itself because they were not injured, their hip was not injured while they were in the service. But because of their back issue, which caused the hip issue, that hip issue could be secondary service-connected, could allow them to receive compensation. Now, this is when I'm getting into the drug and alcohol use. When an individual is diagnosed with post-traumatic stress and they self-medicate with marijuana, with alcohol, it is possible, and I'm only saying it's possible because I've done it, to get that alcohol or drug use service connected. I had a client who was diagnosed and received compensation for post-traumatic stress disorder, and we got him service connection for cannabis use disorder. Don't know how that happened. I don't remember applying for cannabis use disorder, but it happened, and he got more money. And he was able to go into VA, and he was able to get treatment for the cannabis use disorder, which was extremely helpful for him because that's what he wanted. So that's secondary service connection. We also have service connection by legal presumption. It's when an individual receives a diagnosis or is injured as a result of something that the VA later determines, I don't want to say later determines to be their fault, but later determines to be a large group of people who we should just accept have a potential disability. We see this a lot with Vietnam veterans who are exposed to Agent Orange. If they have one of the listed disabilities, cancers, heart diseases, there's going to be a presumption that they were exposed to Agent Orange. The reason for this is before the Agent Orange Act went into effect, the veteran had to prove that they themselves were exposed to Agent Orange. Now, all they have to do is say, I was in the Republic of Vietnam during this period of time. I was in Laos, Cambodia during this period of time. I was in a place where Agent Orange was known to be, and I now have one of the listed disabilities, cancers, health, heart disease, whatever it is. And the VA will presume that their current disability is related to their in-service injury or event, which was exposure to Agent Orange. There's also these for prisoners of war, Gulf War veterans, other chronic health conditions. There is a push right now for veterans who were exposed to burn pits, especially those who were serving in the Middle East during the Gulf War and during the current conflicts. So once those go through, that'll be really, if those go through, those will be really great. And they'll be able to help a large group of veterans who were exposed to big pits in the ground where they just burned a whole bunch of things, and they've received no compensation, even though they have cancers as a result of that. So our hope is that at some point this will come through. Pre-existing injury aggravated by time in service. So if the veteran has an injury or a disease before they entered the service, and it worsened during their service, whatever the worsened level is, the VA will could potentially give them compensation for. But what the VA has to do first is make a determination on what their disability is first, before they entered the service. So say the VA was going to give them 20% disability, and then at the end of it, they would give them 50% disability. The VA will pay for 30%. They'll pay for whatever the aggravation was. There's also service connection due to injury caused by treatment at VA. Think of this kind of like medical malpractice. It's in a Section 1151 claim. When a veteran is injured because of VA hospitalization, treatment, rehabilitation, therapy, whatever, and is not the fault of the veteran, the injury could be considered service-connected and the veteran can get compensation for that disability or whatever occurs. So those are the three main tenets of a service-connected claim. There are a lot of other things that go into them. I wanted to give you guys a like 10,000 foot view of everything. But those are the three main elements of a claim. So a veteran comes to you, they meet these three elements. What are we doing? Well, we have a whole bunch of forms that we need to fill out. First things first, if you are interested in doing veterans benefits work, which I highly recommend you do because it's really amazing work when you get to help these individuals, and it's a really interesting area of law. However, you have to be accredited with the U.S. Department of Veterans Affairs Office of General Counsel before you can give advice on veterans benefits. In the materials that I provided on the website, I included the application for accreditation. So if you want to do this work, you have to become accredited, fill out that application, and you can send it to the VA Office of General Counsel. But what do we do for our veterans? So we have the VA Form 21526EZ. That's just an application. It's like 12 pages, and you fill it out and you send it in. You send in their DD-214. The 2122A is an appointment of representation form. It's just like the Social Security form, the appointment of claimant rep form. And you just fill it out, have the veteran sign it, you send it into VA, you're allowed to talk to VA on the client's behalf. There's a whole bunch of other forms that you have to send in. The VA loves their forms. When an individual is claiming post-traumatic stress disorder, or they're claiming PTSD secondary to a personal assault, there are special forms for that have to be filled out. So I've tried to the best of my ability to lay out the main forms that you will have to use when you're going through this process. You also send in part of the veteran's military personnel file or service treatment records, which are records that you as an advocate can request from the military department or the National Personnel Records Center in St. Louis. I should have noted on there, if you are doing that, the form is called SF-180. It's the standard form 180. You can fill it out, the veteran can fill it out, and you can request these documents. You also can do what's called a disability benefits questionnaire. A lot of those questionnaires disappeared from the VA website. You don't really need them, but they could be helpful. You can also provide private or VA medical center medical records. If they're private records, you have to provide them to VA unless you have the veteran sign an authorization for the VA to get those records. If they are VA medical center records, you don't have to send them into VA because VA has a duty to get those records, just as the VA has a duty to get the military records. However, even though the VA has a duty to get both of the VA medical records and the military and in-service medical records, what I like to do is send excerpts from the military personnel file, in-service records, in-service medical records, or VA medical center records, especially if I'm talking about like a diagnosis or their VA medical records. For all of the things that we know are wrong with VA medical records are some of the best medical records that I have ever seen. There are, at least here in Southeastern Pennsylvania, the Philadelphia and the Coatesville VA Medical Center keep really, really good records. The doctors that and other staff who write these case notes and client stories are really, really detailed and are extremely helpful to us when we're helping the veteran file their application. You also need any other evidence. We also can write a brief or a letter of support. Well, that's not required. When I say we, I mean advocates. It's not required, but it's extremely helpful when you're arguing characterization of discharge. When you're arguing combat or fear of hostile military or terrorist activity, post-traumatic stress. When you really want to put all of the information together in a nice clean bow for VA. Also, you want to do it when a characterization of discharge is necessary, because this gives you the opportunity to argue why the veteran should be considered honorable for VA purposes. Now, all of this is going to be filed with the U.S. Department of Veterans Affairs. It's going to go to the main hub in Janesville, Wisconsin. It's then going to be dispersed out to your local regional office. For the most part, at least here in Southeastern Pennsylvania, our cases go to the Philadelphia regional office. Couple of them may go to Wilmington, but most of them are going to be going to Philadelphia. So the VA is going to acknowledge receipt of the application. They then are going to schedule what's called a C&P exam. It's the compensation and pension examination. And it's going to be for every disability that the veteran has applied for. And it's either going to be with a VA doctor or with a third party. For most individuals, it's with a third party that's contracted with VA to do these exams. The length of time for response from the Veterans Benefits Administration, from the regional office, is going to depend on the type of claim that's filed. So if post-traumatic stress claim, if there's a characterization of discharge, that's going to take a little longer. If there's an emergency status, so there are different emergent statuses available for veterans who apply. Those who are terminally ill, those who are seriously injured in the military, those with under extreme financial hardship, former prisoners of war, those who are experiencing homelessness, those who are suicidal, those who have been diagnosed with ALS, those over the age of 85, that's what the VA considers aged. And so those individuals are going to be able to get a quicker response time. And those who have been awarded the Medal of Honor, and those who are visually impaired. The more boxes you check, the quicker your application goes through. Unfortunately, but also fortunately, because a lot of times, so like a lot of individuals that we work with fall into the extreme financial hardship and homeless category. So when we can put both of those on an application, their application can go through a lot faster, which means they can possibly get benefits a lot faster. Complexity of the disability is also a thing. The number of claims is a thing, and especially, like I said, because of the number of disabilities that are claimed equal the number of C&P exams that have to happen. And any available evidence that you have, any evidence that the VA has to go and get themselves. And then you sit and you wait, and you hope beyond hope that the VA takes 3 months and not 12 months to make a decision. Now, I want to take a little break because I want to talk about calculating service connection benefits, because it makes no sense, but I think it's helpful for us as advocates to understand when we're talking with our clients on how the VA actually does math. So let's say a veteran is applies for and receives compensation for three disabilities: post-traumatic stress, diabetes, and peripheral neuropathy, and receives the disability levels, ratings that are listed here: 60%, 30%, and 10%. For those who don't know, I probably should have said this earlier, VA does their disabilities by percentage. So you can go for any disability you have, you can receive from 0% disabled to 100% disabled, and everywhere in between. So let's say that for these three disabilities, you have 60, 30, and 10. When we add those together, that's 100%. But when VA does their calculation of what the veteran's total rating is, that's actually 80%. How do we get to 80% from that? Now, the reason for this is because, one, there's a table, and two, it's because a veteran cannot get over 100% disabled. So if a veteran has two 60% disabilities, they can't be 120% disabled. That can't happen for VA. So what happens is we have this wonderful table, and we put the disabilities in order, in numerical order, so 60, 30, 10. We find 60% on our table, and then we go over to 30%, which shows us 72. Then we go down to 72, and we go over to 10, which gives us 75. For everything in VA, we follow, this is the only part of math they follow. If it's 4 or below, we round down. If it's 5 or above, we round up. So 75 gives us 80%. So that's how the VA calculates disability compensation benefits. It is extremely difficult when an individual has 80 or 90% to get up to the 100% level, because as you can see, there's so many here that just bring you almost to that level, but don't push you over. It's extremely difficult to get to 100% if you're already at 80 or 90%. That's what that was to say. Okay, now we're on appeals. So does anyone have any questions about anything that I've said over the past 45 minutes? Okay, cool. So we're in appeals. So the veteran has received a notice of denial from the VA. The VA has said, you are not entitled to compensation, or you're not honorable for VA purposes. Whatever it is, you want to file an appeal. Now there are two appeals available, well, one appeal, but there are two systems that we're going to talk about today. There's the legacy appeal system, and there's the Appeals Modernization Act of 2017 system. All appeals filed today are filed under the AMA, but we have to talk about the legacy system because some things are still in the legacy system. So what did the legacy system look like? So the veteran would receive the rating decision. They would then submit within a year of the decision what's called a notice of disagreement. The VA then would send the statement of the case, which is, in theory, could be a new decision. Well, let me rephrase. It's supposed to be a new decision with the VA saying, this is our decision. This is the final decision of the regional office. The veteran can send in new evidence, whatever they want to do, but the statement of the case comes. The statement of the case, the shortest one I ever saw was 30 pages. The longest one I ever saw was like 50. And it's a lot of copy and paste of the US code and the Code of Federal Regulations. And then there's like a little decision at the end. If the veteran still disagrees with the SOC, the statement of the case, the veteran sends in what's called a VA Form 9. It is a formalized appeal of the decision. It has to be submitted within 60 days of the SOC or within the remaining 1 year of the rating decision if any time remains, whichever is later. Generally, we're looking at 60 days from the SOC. Once you submit the VA Form 9, there is potentially a hearing before a Veterans Law judge at the Board of Veterans Appeals. The BVA makes a decision. You disagree with that decision, you have the ability to file an appeal to the U.S. Court of Appeals for Veterans Claims within 128 days after a BVA decision. The CAVC issues their decision, and then you can go to the Federal Circuit and the U.S. Supreme Court. So that is the legacy system. That's what the system used to look like. Now, the reason that I'm talking about it now in 2020 is because there are still some cases that are in the legacy system. The legacy system is only for appeals that were issued before February 19th, so on or before February 18th, 2019. Everything that was issued on or after February 19th, 2019 falls under the AMA. But why did we need the AMA? In a Federal Circuit case in 2018, Circuit Judge Moore wrote a concurring opinion in which she eviscerates the VA because of the long wait times. I'm sure everyone remembers the constant news stories about the terrible wait times at VA. And she took a lot of time in her opinion, and I highly recommend you read the opinion if you are interested in this work, because she breaks down what each step is and then really brings into question how these times are a thing. For example, from VA's receipt of the notice of disagreement to the time that they sent in their statement of the case in 2017 was 500 days. From the receipt of the Form 9 to the certification of appeal was 773 days. And when you read Circuit Judge Moore's opinion, as she explains it, that certification of appeal is filling out a 1 to 2 page form. But that took the VA 773 days. From the certification of appeal to the board receipt of the appeal was another 321 days on average, which means the transport of the file of the veteran from the local regional office to the Board of Veterans Appeals in Washington took almost a year. Then from the board receipt to a decision made by the board took another 247 days, where in 2017, the average wait time for a veteran on sending in a notice of disagreement was over 1,800 days, or just over 5 years. I had so many clients when I, at my last job, I had a Vietnam veteran come up to me and actually say, I think the VA is just waiting for me to die before they make my decision, before they make a decision on my claim. It's a really hard thing to hear. The AMA is supposed to make the process faster. And as we've seen in 2018 and 2019, the average wait time has gone down. We are now at almost 1,400 days as opposed to over 1,800. So yes, that's good. That is a little better. It takes a long time. We understand that. It's a bureaucracy. It's a large bureaucracy. The VA is one of the largest federal agencies. We understand that. But still, it takes a very long time. But what is the AMA? The AMA, signed into law in August of 2017, fully implemented in February of 2019, restructured the entire appeals process. It created 3 lanes for a veteran to file an appeal through. And we'll talk about each one in particular. So the higher level review, the veteran gets to file a request that their regional office issue another decision based on a higher level review of the claim file. And a higher level review is done by another claims representative, another employee of the VA, who has a better record and who has had different and higher level training. Review is, like I said, review is conducted by a more experienced rating specialist. Importantly, the veteran is able to maintain the same effective date so long as they file their HLR within a year of their regional office decision. But the downfall to the HLR process is you are not allowed to submit any additional evidence. You are only allowed to have a decision based on the claims file as it exists at the time that the VA made their initial decision. So if you think there's just something wrong with the initial decision and you think that you want fresh eyes to look at it, the HLR could be a good way to go. The next lane is the supplemental claim. The supplemental claim process allows you to submit evidence the VA calls new and relevant evidence. It's a different standard under the AMA than the old standard. Relevant evidence, new evidence is any evidence that is not a previous part of the record, and relevant evidence is information that tends to prove or disprove a matter at issue, and it includes evidence that raises a theory of entitlement that was not previously addressed. So it's a lesser standard than that was available before, which is good, but you have to show that any evidence that you're submitting under the supplemental claim is new and relevant. Again, the veteran will maintain the same effective date, which when I'm talking about effective date, a veteran is entitled to receive service-connected compensation from the date that they file their application. So long as they continue the process and they file appeals timely, like a veteran could file, like if a veteran filed their application today and they don't get a final decision from the Board of Veterans Appeals until 2025, they will receive retroactive benefits from that date that they received the decision to today. So they could potentially receive 5 years of back benefits so long as they continued their application in the proper way and they filed their appeals timely. You also are allowed to file a supplemental claim with new and relevant evidence after an HLR decision. So as you see with this wonderful, colorful flowchart, the whole point of this new system is to allow you to move between the different lanes at different times in hopes of making these decisions within the VA and making them as quickly as possible. And the final lane is the appeal to the board. So the veteran can appeal and what this does too, what the AMA does is allows the veteran to go straight to the board and bypass the regional office as they had to in the legacy system. So veterans can file straight to the board. They don't have to go through the higher level review. They don't have to go through a supplemental claim. If it's a legal matter and you want to be in front of a judge, as an advocate, you want to go in front of a judge, you can file a notice of disagreement and skip all of those other systems. There are 3 dockets within the board that we're going to talk about in a second that you will fall into, and depending on what evidence or hearing you want, you can choose which docket. So there's the direct docket, which is kind of like the higher level review process. There's no additional evidence and there's no hearing. The board is just going to make a decision. Their goal is to do it within 365 days. The board will make a decision on whatever's in existence in the claims file. There's the evidence docket. You can submit additional evidence, but there's no hearing at the board. And you have to submit all of your additional evidence within 90 days of your the filing of your notice of disagreement. There's also what's called the hearing docket, which allows you to submit additional evidence, but like the name says, you will have a hearing in front of a veterans law judge. It will either be in person in Washington, obviously not right now, or it will be via teleconference, which all VLJ hearings are being held right now. Most VLJ hearings are held at your local VA. So it could be held like here in Southeastern Pennsylvania, could be held at the Philadelphia Regional Office, the Philadelphia Medical Center, could be held at the Wilmington Regional Office, the Wilmington Medical Center. So wherever your local VA regional office or hospital is, you may go there for a hearing, and they have all of the technology set up for you to have a teleconference with the judge. But what if you still don't like any of your decisions at the board? You file an appeal to the U.S. Court of Appeals for Veterans Claims. The U.S. Court of Appeals for Veterans Claims is an Article I court. However, it's still a court of appeal. So this is a place for making legal arguments. All of the facts have to have been decided by the board below. The BVA, under administrative law standards, the BVA is the final agency determinator of all facts and everything. So once the BVA makes a decision, that's it. Then you go to the Court of Appeals for Veterans Claims. Except after a CAV decision, you still can file a supplemental claim and get back into the process, but we're not going to talk about that right now. But the CAVC, you file a notice of appeal within 120 days, and it's an appellate court. There's you file briefs, and this is actually the first time that you're really going up against an attorney from the VA Office of General Counsel. At every stage before the CAVC, it's all veteran friendly. It's non-adversarial. But once you get to the CAVC, you're making those legal arguments before a panel of judges. The VA Office of General Counsel steps in. If you still may have a disagreement after a decision by the CAVC, you can file an appeal with the Court of Appeals for the Federal Circuit. And then, of course, you can file with the U.S. Supreme Court. I used to say that there are not a lot of VA cases at the U.S. Supreme Court, except this last term, there was quite a few of them. They're not generally on benefits themselves. They're on different parts of administrative law. So if you're interested in administrative law, a lot of V. Wilkie cases, so someone V. Wilkie, came down through the U.S. Supreme Court this last term. They're pretty interesting if you like administrative law. There are a lot of resources available for advocates who are interested in doing veterans law work. The National Organization of Veteran Advocates is our national organization. If you're interested in becoming a member, all of these links should be clickable on the materials that you were given. If you have any questions, please feel free to give me a call and I'll help you connect to anyone. The National Law School Veterans Clinic Consortium just did a boot camp at the beginning of September, or maybe it was August. I'm pretty sure it was September. And it was really amazing. And I definitely recommend you going, and if you're interested in this, looking through a lot of the materials that are provided there. Swords to Plowshares has a lot of self-help guides that are client-facing. So they're specifically written to help veterans, spouses, family members, whoever, with individuals on their own. But they're also extremely helpful to us because it puts in plain language what the VA or the DoD are looking for. I also highly recommend the Veterans Benefits Manual. It's a huge, thick book published by Nexus and the National Veterans Legal Service Program. It is literally everything you ever want to know about veterans benefits in a, I can't say compact book because I think it's like almost 2,000 pages. There's a whole bunch of forms, regulations, statutes. Like I said, all of these are clickable. And then the U.S. Court of Appeals for Veterans Claims, because it is an appellate court, if you ever do want to get to, want to have a case there, you do have to get on the bar of the U.S. Court of Appeals for Veterans Claims. But it's like getting on the bar in any federal court. So that's what that is. This is all of my information, my office number, my work cell number, my email. We also have a veterans intake helpline for any veteran in Bucks, Chester, Delaware, or Montgomery counties. If anyone has any questions, I'm more than happy to sit here for however much longer we have. And please feel free, call me, email me, whatever. I'm happy to talk to anyone about any veterans issues that are going on.
Thank you so much, Richard. I'm now going to launch the second of the 2 CLE poll question boxes. Also, if anybody has any questions or comments from Richard's presentation, if you could type them up in the chat box now and send them to everybody, I think he'd be happy to take some questions. Well, we have somebody wrote, great presentation, thank you. Not seeing any questions, so we'll just have to give the poll box a little bit more time, and then we will get you out of here early, I guess. That was a lot of information you shared. Good information, though. Very interesting, I thought. Okay, well, we're not having any new responses to the poll box, so thanks for being with us, Richard, and everybody else. Thanks for joining us here today, and we will see you next time for the next session of the conference. Thanks, everybody. Take care.